108. Joint sitting of both houses in certain cases. 1. If after a bill has been passed by one house and transmitted to the other house, a. The bill is rejected by the other house, or b. The houses have finally disagreed as to the amendments to be made in the bill, or c. More than 6 months elapse from the date of the reception of the bill by the other house without the bill being passed by it, the President may, unless the bill has elapsed by reason of a dissolution of the House of the People, notify to the houses by message if they are sitting or by public notification if they are not sitting, his intention to summon them to meet in a joint sitting for the purpose of deliberating and voting on the bill, provided that nothing in this clause shall apply to a money bill. 2. In reckoning any such period of 6 months as is referred to in clause 1, no account shall be taken of any period during which the house referred to in sub-clause c. of that clause is prorogued or adjourned for more than 4 consecutive days. 3. Where the President has under clause 1, notified his intention of summoning the houses to meet in a joint sitting, neither house shall proceed further with the bill, but the President may at any time after the date of his notification summon the houses to meet in a joint sitting for the purpose specified in the notification, and, if he does so, the houses shall meet accordingly. 4. If at the joint sitting of the 2 houses the bill, with such amendments, if any, as are agreed to in joint sitting, is passed by a majority of the total number of members of both houses present and voting, it shall be deemed for the purposes of this Constitution to have been passed by both houses, provided that at a joint sitting, if the bill, having been passed by one house, has not been passed by the other house with amendments and returned to the house in which it originated, no amendment shall be proposed to the bill other than such amendments, if any, as are made necessary by the delay in the passage of the bill. b. If the bill has been so passed and returned, only such amendments as aforesaid shall be proposed to the bill and such other amendments as are relevant to the matters with respect to which the houses have not agreed, and the decision of the person presiding as to the amendments which are admissible under this clause shall be final. 5. A joint sitting may be held under this article and a bill passed thereat, notwithstanding that a dissolution of the House of the People has intervened since the President notified his intention to summon the houses to meet therein. 109. Special procedure in respect of money bills. 1. A money bill shall not be introduced in the Council of States. 2. After a money bill has been passed by the House of the People, it shall be transmitted to the Council of States for its recommendations, and the Council of States shall within a period of 14 days from the date of its receipt of the bill return the bill to the House of the People with its recommendations, and the House of the People may thereupon either accept or reject all or any of the recommendations of the Council of States. 3. If the House of the People accepts any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both houses with the amendments recommended by the Council of States and accepted by the House of the People. 4. If the House of the People does not accept any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the House of the People without any of the amendments recommended by the Council of States. 5. If a money bill passed by the House of the People and transmitted to the Council of States for its recommendations is not returned to the House of the People within the said period of 14 days, it shall be deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by the House of the People. 110. Definition of money bills. 1. For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely, A. The imposition, abolition, remission, alteration or regulation of any tax. B. The regulation of the borrowing of money or the giving of any guarantee by the Government of India, or the amendment of the law with respect to any financial obligations undertaken or to be undertaken by the Government of India. C. The custody of the Consolidated Fund or the Contingency Fund of India, the payment of monies into or the withdrawal of monies from any such fund. D. The appropriation of monies out of the Consolidated Fund of India. A. The declaring of any expenditure to be expenditure charged on the Consolidated Fund of India or the increasing of the amount of any such expenditure. F. The receipt of money on account of the Consolidated Fund of India or the public account of India or the custody or issue of such money or the audit of the accounts of the Union or of a state, or G. Any matter incidental to any of the matters specified in sub. 1, clauses A to F. 2. A bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. 3. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the House of the People thereon shall be final. 4. There shall be endorsed on every money bill when it is transmitted to the Council of States under Article 109, and when it is presented to the President for assent under Article 111, the certificate of the Speaker of the House of the People signed by him that it is a money bill. 111. Assent to bills. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill, or that he withholds assent therefrom. Provided that the President may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill to the Houses with a message requesting that they will reconsider the bill or any specified provisions thereof and, in particular, will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the Houses shall reconsider the bill accordingly, and if the bill is passed again by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. Procedure in financial matters. 112. Annual Financial Statement. 1. The President shall in respect of every financial year cause to be laid before both the Houses of Parliament a statement of the estimated receipts and expenditure of the Government of India for that year, in this part referred to as the Annual Financial Statement. 2. The estimates of expenditure embodied in the Annual Financial Statement shall show separately a. The sums required to meet expenditure described by this Constitution as expenditure charged upon the Consolidated Fund of India, and b. The sums required to meet other expenditure proposed to be made from the Consolidated Fund of India, and shall distinguish expenditure on revenue account from other expenditure. 3. The following expenditure shall be expenditure charged on the Consolidated Fund of India. A. The emoluments and allowances of the President and other expenditure relating to his office. B. The salaries and allowances of the Chairman and the Deputy Chairman of the Council of States and the Speaker and the Deputy Speaker of the House of the People. C. Debt charges for which the Government of India is liable including interest, sinking fund charges and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt. D. I. The salaries, allowances and pensions payable to or in respect of judges of the Supreme Court. E. The pensions payable to or in respect of judges of the Federal Court. E. The pensions payable to or in respect of judges of any High Court which exercises jurisdiction in relation to any area included in the territory of India or which at any time before the commencement of this Constitution exercised jurisdiction in relation to any area included in 1. A Governor's province of the Dominion of India. A. The salary, allowances and pension payable to or in respect of the Comptroller and Auditor General of India. F. Any sums required to satisfy any judgment, decree or award of any court or arbitral tribunal. G. Any other expenditure declared by this Constitution or by Parliament by law to be so charged.